welcome everyone. My name is Leah and I am the Knowledge Exchange Manager at Women's Shelters Canada, and I'm going to be hosting our webinar today, moderating the conversation. And I'm really excited to get into this. I think it's going to be a really, really good conversation. Before I get started, I want to start by acknowledging that I'm joining you today from the traditional unceded territories of the Algonquin and Anishinaabe people. And I know with this virtual setting, part of the beauty of it is there's folks joining us from all across Turtle Island today. And so please do feel free to say hi in the chat, let us know where you're joining us from. And we would love to get to know who's in the virtual room with us here today. And of course, if you don't know what territory you're on, if you're not too sure about that, this is a gentle reminder to use this as an opportunity to find out a little bit more so that you know next time. So again, just a few little housekeeping reminders before we get into the conversation. Today's conversation will be happening mostly in English. So as I've said, if you would like to listen in French, please do feel free to turn on your interpretation at the bottom of the screen using the interpretation button. And my colleague has put the instructions for that in the chat as well. And as I mentioned earlier, you do have the option to control your subtitles there. You can turn them on, you can hide them, you can open a transcript up. So to do all of that, you can use the CC button at the bottom of your screen. You have probably noticed that only our panelists today have their audio and their video set up here, and we're just doing that to make sure we have sort of clear audio for everyone, since there's quite a few people joining us today. But it doesn't mean we don't want your participation. We definitely want your participation, and there's a few ways you can do that. So you can use the chat, like some of you are doing already, to introduce yourselves. You can use the chat if you want to make a comment. If you have a technical question, that's a good place to put it, and my colleague and I will do our best to help you out. If you have a question that you would like to ask our presenters or our speakers that I'll introduce in a minute, we would ask that you put that in the Q&A box, which is just beside the chat on your screen there. And that just helps us keep track of those questions, keep them in one place, and that way we're able to cover everything rather than missing something in the chat. So please do feel free throughout the session to put your questions in the Q&A, and we will have lots of time to answer those. And I also wanted to note we are recording today's webinar, and we'll be able to share the recording afterwards with folks who have to leave early or join late or couldn't make it today because something came up. So with all of those little housekeeping reminders done, I'll jump right in. And so today, as you all know, we are here to talk about navigating concurrent legal processes with survivors of domestic violence. So as I'm sure everyone here knows, one legal process can be more than enough to figure out and to deal with, particularly for someone who is just, leaving or dealing with a violent relationship. And so it's even more to deal with when there's multiple different legal issues going on. Maybe there's a question about immigration, maybe there's family custody conversations going on, maybe there's a criminal charge. And so how do all of these things interact? How do they impact each other? And what should we be watching out for? So that's what we're going to talk about today. And to do that, we are joined by two wonderful speakers. So we have with us Shalini Konanur, the Executive Director of the South Asian Legal Clinic of Ontario, and Kim Hawkins, the Executive Director of the Rise Women's Legal Centre in BC. So we are super happy to have the two of you join us, and we are actually going to start today, or to run today's webinar, a little bit more of a panel style, a conversation rather than formal presentations. So hopefully that will be really engaging and fun for everyone here. So before we get into that conversation, we would like to know a little bit more about all of your experiences, those of you who have joined us here today. So I'm going to launch a poll. It should pop up on your screen right now. And we would like you to just take a couple seconds to answer, give us a sense how much experience you have working with clients on issues related to their immigration status, criminal charges or trials, and then family law. It would be really interesting to just get a sense of, who's in the room, what you've seen, what you're facing in your work. So I'll give you a couple seconds to respond to that, and then we'll take a look. So many of you are participating. That's great. I'm going to give it about 10 more seconds. All right, so I'm going to end that and share those results. So it looks like generally folks don't have a ton of experience with immigration. A little bit more experience with criminal issues. So some folks saying lots of experience, but the bulk of people, 50%, are sort of in that some experience range. And then say similar with family law. So overall kind of more experience with family law, which I think is probably what we might have expected with this audience, with those of you who are here. So that's great. It's super interesting to have that. So thanks everyone for participating. And so without further ado, I think we'll jump right into our questions. And I'm going to start with Shalini with a question for you. If you could just, since folks sort of mentioned there's a little bit less experience with the immigration side of things, if you could give us a sense, just to start off, of how the immigration system impacts women who experience family violence and how some of those immigration issues might impact other legal processes, such as family or criminal.
Absolutely. And I want to thank Women's Shelter Canada and everyone who's spending this time with us this afternoon. What I think is really interesting about the conversations of the intersection between immigration and family and criminal law is that we now have growing data in the country that people with precarious and no immigration status are actually spreading across the country. When I started, the picture was that largely they would be in sort of Ontario, Quebec, and BC, and that is actually not the case at all. In fact, that Ontario is receiving fewer and fewer people coming in. So it's a really timely thing to think about how immigration impacts, because as we move ahead in terms of trends in immigration, we will see more and more of those populations as far east and as far north and as far west as all of the people participating are today. And so the first thing really, and I should say that I run a legal clinic funded by Legal Aid Ontario in the province of Ontario, and I work with low-income South Asian communities. So our clinic actually practices a little bit in criminal, family, and immigration. So we get to see in a live way how those things interact for our clients. And the truth is, immigration can be a key consideration for women who experience family violence. If they have what we dub as precarious immigration status, which I'll explain in a sec, or no immigration status, that actually becomes one of the critical pieces in their decision-making on what they're going to do about their family violence. And I'll tell you why. But when I say precarious immigration status, what we mean by that is people who are here temporarily, like visitors, people on work permits, people on study permits, people on something called a temporary resident permit. And it can also mean people who are permanent residents. So in the immigration system, having permanent residence, which we used to call landed immigrant status, doesn't mean you're entirely safe when you leave a situation of violence. And then we have a growing population of people in Canada with no status. The reality is that the immigration system at present is a mess. It is so backlogged that many people who are in Canada have fallen out of status and can't figure out how to fix that with immigration. So you've got those two populations working together. And the reality for most of the clients I see is that in most of those cases, they are relying on an abusive partner to ensure that they either maintain their current immigration status or that that person is going to help them become a permanent resident or a landed immigrant. So just by logic, once you know that If I am thinking I need to stay with this person because my immigration status might be threatened, that changes the way I'm going to think about what I want to do in terms of family violence and my agency to do anything. Some of the examples for the clients, I think it's good to give examples because that helps people to kind of get a better understanding of what I'm talking about, is that we have many clients who come to us and they're with a partner who has put in Canada spousal sponsorship. So they say, if I leave, I'm not going to get permanent residence. Many are with a partner who's here on a work permit and they come as the accompanying partner. So they get also a work permit or study permit or visitor visa, but it's tied to the fact that they're with the main work permit holder. And if they separate, that status can go away for them. So there are so many different ways in which people get, and women in particular, get tied to the status of their partner and then have to make a decision on what to do. I want to say really clearly what I think, and this is my opinion, but largely the opinion of many people who practice immigration, is that the way in which immigration law and policy is currently set up is in and of itself, to me, a form of state-sanctioned violence. There is not enough protection for women to be able to make a free choice without having to worry about losing immigration status. And in addition to that, even if I'm here as a permanent resident or a landed immigrant, as they used to call it, my partner can call IRCC, which is Immigration, Refugee, Citizenship Canada, and make a complaint that I just used them to get immigration status. And in those cases, over the years, we've had to deal with hundreds of misrepresentation claims where women who left because of abuse have to prove their abuse to immigration so that they can keep their permanent resident status. And I cannot tell you the trauma and fear that is faced by that process, which sometimes can take upwards of 2 years. So in addition to the trauma of having left and dealing with the system and all the other concurrent legal issues, the trauma of not knowing what's going to happen to your own immigration status will weigh heavily on those clients. So really, we're looking at a situation where a lot of the clients I see are making decisions around whether they should do anything about violence or whether the immigration precarity would prevent them from doing it. And it's a really hard choice to make. I don't judge them for the difficulty of trying to make that decision because I don't have good answers for them on the immigration side. I cannot say you'll be okay 100%, which I think is ludicrous and makes me frustrated with the lip service of governments at all levels around gender-based violence and, equality and equity for women, because really the large majority of the people who are encountering this issue are women or identify as women. So yeah, that's a really tough piece. So that's kind of how immigration impacts someone facing family violence. But how does it flip? How does it impact the family court process? That's kind of the second piece of the question, right, Leah? Right? So in many ways, it can impact the family law process. And we have clients who go into a family court without immigration status, and their partners try to use that against them, right? In arguments around parenting time and decision-making time, immigration precarity can sometimes be a negative for that person. But in many ways, we have also used the family court to have a positive impact on the immigration side, where we do get family court orders that clearly state that it's in the best interest of the children for the person to have parenting time, to have decision-making time. Those then can be taken into the immigration process and say, you have to let this person stay. The family court order is in place. It's in the best interest of the children. You should regularize their immigration status so they can stay and abide by the family court order. So in many ways, it can be helpful. And the experience is different across the country in terms of how that plays out in family court. Here in Ontario, what's been interesting, one of the shifts that has been really interesting for me is where CAS is involved and is actually sitting in the family courtroom and navigating advocating for the woman and helping and advocating for the woman and advocating on the immigration side. When I started about 23 years ago, CAS would never write support letters on my immigration files. Now it's a matter of course here in Ontario that they will advocate for the woman to be able to stay because it's critically important for the children. So there's some really good things at play that can happen in the family court process. We also use it, of course, for things like a specific order allowing a parent to apply for citizenship for their kids without the consent of the other parent. We use it for allowing a parent to travel with the kids without the consent of the other parent. So there's so many ways in which that immigration piece can intersect with that family court piece. And I think I'll leave it at that for now, and I'm sure we'll get into it more.
Awesome. Thank you. That's so interesting. And also to think about, you mentioned both some challenges it can raise, but also some positive kind of connections between the family and the immigration, which is super interesting. So Kim, I'm wondering if I can go to you now to sort of build out the criminal law side of things a little bit more and talk about sort of some of those overlaps and differences between family law and criminal law.
Yeah, for sure. Thanks. And so, yeah, also thank you to everybody for being here today. It's morning where I am, but and I'm in Vancouver. I'm on the territory of the Musqueam, Squamish, and Tsleil-Waututh First Nations, and so really honored to be able to live and work here. So like family and immigration, family law and criminal law often overlap for our clients. I work at an organization that provides mostly family law services, mostly to women fleeing violence, but the processes are really, really different. So they can react very differently to the same type of events. They also don't speak to each other. So people often come in thinking that because they're in court in multiple proceedings, that somehow the family court knows what's happening in criminal court or criminal court knows what is happening in family court, but the processes really don't talk to each other at all. So they can happen quite independently and in quite a siloed ways. They're also decided, and I'm sure people have heard this, they're decided on two very different evidentiary standards. So you might have somebody going to criminal court where something has to be proved beyond a reasonable doubt, and also have a family law case where it has to be proved at a lower standard. And people may wonder why somebody is let off in criminal court, but something can happen in family court, or people may be discouraged from pursuing things in family court because somebody wasn't convicted at criminal court or charges weren't laid. And there can be all sorts of assumptions read into that means that nothing happened, that there was no violence or the violence wasn't serious. And that's not at all the conclusion that we should draw. So some really big differences between the way that the systems operate. I might just start really quickly highlighting one of the similarities, which we really find to be a struggle for women across the board. And this isn't going to surprise, I think, the people on this call, which is that there's a lot of shared attitudes and a lot of shared misunderstanding of violence, and very particularly towards non-physical violence. So between 2018 and 2019, my organization conducted 27 focus groups across BC in 25 different communities, and we spoke to over 160 participants that included women with lived experience of violence and support workers. And what we've heard really clearly and very consistently across both family law and criminal law systems is a sort of shared inability to recognize violence, and particularly if it's non-physical. And an inability to really address risk as opposed to waiting for violence to happen and then responding to it. And so that's been true whether we were talking about police officers, family lawyers, judges in both types of courts. Women consistently felt that people in the justice system didn't understand the impacts of the non-physical violence and did not understand the safety risks they were facing. And this is very consistent with what we've also seen in academic research, that coercive and controlling behavior doesn't receive a priority response. It may not be understood as being controlling by courts. Both of the systems are quite skeptical when women bring claims of violence, particularly when it's happening post-separation. So particularly when it's happening in the breakdown of a relationship, there's a tendency to think that this is somehow being made up to get revenge or as part of gaining an advantage in family court. And that tends to be a lens through which things are viewed. And some of the really particular forms of abuse that we find are not understood well by either system are kind of psychological and emotional abuse, threats, and also cases where there's financial abuse and people withholding funds. And these attitudes run so deeply that we see, we can actually point to numerous examples, even within the last couple of years, of police and judges and lawyers being wrong on what the law actually is because of how deeply these attitudes and these stereotypes run. So for example, just a few months ago, we were contacted by a community partner in a small town in BC. And she was reaching out. She was on a committee meeting that included representatives of a bunch of organizations, including Crown and Police, and they had just done a training on peace bonds. And they had been told during that training that peace bonds are only able to address physical violence and they can't address psychological harm, which is simply not true, right? It's simply demonstrably not true. We have case law going back to the 1990s saying that that's not correct in law. Similarly, we had a lawyer go into family court in BC earlier this year and appear in front of a family judge. And she started talking about how funds had been withheld as a form of family violence and how somebody hadn't had access to family resources. And he said, well, that's not violence. And she had to take him to the actual definition section of the act and say, no, that in BC is explicitly identified as family violence. And then, of course, we see lots of threats, even threats that are very documented in text messages, in emails, and a threat to cause death, to cause bodily harm is again, black letter criminal code offense, and the police aren't seeing that and aren't laying charges. So I just sort of wanted to upfront say these attitudes that people experience are really cross-cutting and very deep. But then the two systems themselves differ in some really important ways. So most women are going to engage with the criminal system at the point where they contact the police for protection, usually either a peace bond as a result of some sort of criminal offense. We know that many women don't feel safe calling the police. So there's real differences in how this kind of supposedly protective mechanism from society is experienced by different people. So certainly there's a significant underreporting of interpersonal and sexualized violence in Canada. That's particularly true for racialized communities, Indigenous women who may not feel that they're going to get protection and safety, and that's a real unfairness that exists. We also know that police officers themselves engage in violence against their spouses at a much higher rate than the general population. So we also have a subset of people who don't feel safe contacting the police because their abuser is a member of the police force. Once the police are contacted, if they take up the matter, if they lay a criminal charge, if they lay a peace bond, the client to a large degree loses control of the case at that point. So the major processes in a criminal proceeding are taken over by Crown Counsel. They're responsible for doing the prosecution of the offense. They may consult with the victims, and our experience is that varies a lot between sort of different police and different crowns. So some of them will be quite good, some of them will not consult at all. But ultimately in a criminal process, the victim is more or less treated as a special witness. So they don't have any standing in their own right to ask questions during the trial or to make any submissions. The Crown can enter into negotiations with the accused person and agree to a plea bargain, without the victim's agreement to what that looks like or what's included in it. And they can also choose not to proceed with charges if they feel that they're not something that the Crown wants to go ahead with. As a general rule, the Crown is making their decisions about proceeding on a case on two criteria. The two things that they're usually looking at: is there a substantial likelihood of conviction? And then secondly, is it in the public interest for them to do the prosecution? And so because one of the things they're looking at is, am I likely to win this case? And that's kind of a barrier that they have to pass before they prosecute. There can be all sorts of reasons why the Crown might decide that they're going to stay a charge that have nothing to do with the woman's, nothing to do with her actions, and that can be quite difficult for people to understand. It could have been something that the police did when they were arresting the accused person. Maybe they breached charter rights, or maybe they did something else, and a Crown might make a decision that they don't think they're going to win on this, and it can be nothing to do with what kind of the victim's evidence or what she did or said. And she may likely not be consulted. And because the Crown also have a lot of discretion, they aren't required to tell anybody what their reasons are for doing any of this. So, the process can be really disempowering for people. There is, it is the route to getting some of those remedies, like having people incarcerated if that's something that the woman is looking for, which definitely isn't always the case. but it can be, there can be a real lack of ability to direct and influence what the proceeding looks like. That can also start right away at the bail level, because you could go in, charge somebody, and they could immediately be put on bail conditions which take them out of the house, or maybe create a no contact situation, but don't create any mechanism for financial support if she's reliant on him for financial support. If there are shared parenting arrangements, for example, she's relying on him to pick the children up from music lessons, all of a sudden that can be gone in the criminal system with very little, again, ability to actually influence it. So there can be, yeah.
Sorry, I'm just going to ask if you can slow down a little bit just for
Sure.
the interpretation. Thank you.
Sure, sorry. So the criminal process as well is also decided on that very, very high beyond a reasonable doubt standard. The family system there's some benefits and pros and cons to everything. So the survivor will have more control over the family court process in the sense that they have standing in court. They can request particular orders from the court. You don't have police and crown playing the same gatekeeping functions in the family court as you do in the criminal court. Cases only need to be proved on a balance of probabilities instead of beyond a reasonable doubt. So it's a lower threshold of evidence, at least in theory, that's required to be able to get an order. But I also think it's really important not to underestimate the additional burden that the family court system places on survivors, because now what we've done is we've said you're responsible for your own protection. You're responsible for running your own case, for either appearing as a self-represented litigant, because a lot of communities in Canada and a lot of provinces don't have strong legal aid funding, or you have to find the funds to now pay for a lawyer out of your own pocket and get a lawyer to run your case. So we're really shifting that burden of protecting people from the state onto the individual person. Providing evidence of violence is always a major challenge for both courts. We know a lot of people don't engage in really overtly abusive conduct in front of witnesses. So often that is a real challenge for people when they go into court and then have to describe interactions, which can be quite subtle. To outside people or to people who haven't been able to witness what's going on. And so this really creates, it creates a double bind for people. If they don't call the police for help, people can conclude that the violence wasn't very serious. On the other hand, if they do call the police may not take the matter seriously, or they may make things worse, or they may fail to take any action. They may also refuse to answer if a woman has called multiple times and chosen not to relieve the relationship right away. So it's a really complicated set of interactions between the two systems, and again, they don't play well together often.
Awesome, thank you, Kim. It's so interesting, and now that we have this kind of overview of the immigration, the criminal, and how those interact with family, I'm wondering, and I'll go to both of you on this. I'll start with Shalini, and then I'll go to Kim. If you could just talk a little bit about some of the challenges that women face, or a woman might face, when she is dealing with these different kind of processes at the same time, or in her case. And you've both kind of touched on some of that already, but if there's anything you want to expand on or add. So Shalini, go ahead.
Thanks, Leah. I just actually wanted to touch off on something Kim said about the criminal process really quickly. So in a lot of the cases we deal with, when a criminal process is going on and concurrently there's an immigration issue, a very interesting thing happens. Pressure is often put on the victim to speak to the Crown and sort of provide their wishes that they don't want to proceed in exchange for continuing an immigration process and getting permanent residence, which is a really interesting piece and a tactic used, we've seen it used many, many, many times, that suddenly everything about the situation is rosy, the person is going to continue the immigration application and they're very sorry, and please let the Crown know that maybe you don't want to proceed. And invariably, in the cases where that is successful, and as Kim said, it's really up to the Crown as to whether they're going to drop charges or not. I have seen situations where they will take into account what the victim says and some where they just won't. And so if they do, based on what what a victim has said to them, in many of those cases, we then see, though, that the immigration promise that was made to them is not carried through. So that is a really interesting intersection, and I think one that is more and more common amongst the cases that we see. In terms of biggest challenges, obviously the first one is what I spoke about before, that it is really, really scary to think about dealing with a family violence situation where you might lose your immigration status. And no, as clients are told sometimes by consultants or other people or immigration lawyers in some cases that they will be okay. And the truth is, we don't know that. As immigration practitioners, their options for what they can do, a humanitarian and compassionate application, a temporary resident under the family violence program, they're all discretionary. We can never say to a client, we can fix this on the immigration side. We can advocate, there is a fair bit of success, but the reality is there's no certainty. And so I think that is a scary and massive challenge for clients. Then following from that, the biggest challenge is there's really an access to justice issue on the immigration side across the country. The ability to find supports is almost non-existent. And I'm in the province that probably has the most robust sort of legal aid scheme that will give you support and includes legal clinics that do immigration law. But I actually speak to frontline workers from across the country. Just yesterday, I was speaking to somebody from Nova Scotia because people are scratching their heads trying to figure out where can I get that information and that knowledge. The immigration bar is not massive in most parts of Ontario, let alone the rest of the country. So I do want to say there that and I put myself out there saying this, but that if you're completely flummoxed and confused, you know now that you've seen me, you can reach out to me even if you're not in the province, because I'm determined to try to get information into as many people's hands as I can. And the good thing about immigration is it's federal, right? So what happens in Ontario is what happens in BC and Alberta and Nova Scotia and New Brunswick. And so those are pieces. If you go on the internet in Ontario, there's something called the Steps to Justice website, and it has some really robust information on immigration. And on immigration in particular, it's relevant regardless of where you are in the country. Some of the resources may not be like where to go in Ontario, but the information is. So there are some good resources out there. I think one of the other major challenges is because immigration has become so backlogged because of the pandemic, they're not even taking calls for most people. Like, you cannot call them and get information. They have told us that except for cases of violence. So they will speak to a client if it's a situation of violence. The only thing I caution is that you don't want to make a call to immigration with your client unless you're sure it's not going to trigger something worse for them. Like if they're out of status and they maybe have an immigration warrant for their arrest, you want to pull back before you call immigration and let them know where this person might be. And so really it's about trying to figure out in the space you're in who you can consult with to get information into hands of those clients. And the other thing really quickly is immigration status is a precursor to access to almost every support that the clients I work with need when they're dealing with situations of violence. So depending on your immigration status, you may not have access to social assistance, to subsidized housing, to healthcare coverage, and that also depends on what jurisdiction you're in around the country. And so those are all big challenges, I think, for people when they're dealing with that intersection of immigration and violence.
All right, thank you. Kim, what would you like to sort of add, and with the same question there around criminal?
Yeah. So one of the problems that we definitely see with that interaction, and I touched on it really briefly, but is the way that we find, and it'd be interesting to see now that there have been changes to the Divorce Act, which tend to mirror some of the changes that had already taken place in BC's family law. The police would really rather not deal with anything that they see as being like a private dispute between families and family issues. They're very reluctant to engage. And so I would say one of the ways that the protection order regime in BC has really backfired. The sort of civil protection system is that it's given police an out. So instead of laying charges or instead of getting a peace bond, they're now like, oh, you have to go to family court and we don't want to deal with it. So again, sort of that shifting that burden onto women to protect themselves instead of being able to rely on the state to actually take steps to make sure that they're safe. And then on the back end, what we're seeing is that police don't take those family orders nearly as seriously if they are broken. So if someone goes and gets an order that's supposed to protect them, the police may not enforce it. They may just do multiple warnings, or they may do nothing, or after it's been broken enough times, they may decide at that point that they're going to get a peace bond, which is really basically the same thing and doesn't make any sense. So we're really seeing, I think we've really seen that shift and that kind of failure to take family court protection seriously. Being taken really seriously is really a challenge across the board. So again, we know that lawyers and judges are supposed to be taking family violence into account. Actually, most of them don't have training. They don't kind of have experience in doing it. And certainly in BC, and I think it's true across the country, there usually isn't any sort of mandatory training. So what we know, again, a lot of people are coming to speak to family lawyers who are saying, don't talk about violence and don't tell them, basically either not asking the question in the first place or finding out about family violence and saying, we don't want to talk to the judge about it. And so we really see this real pressure for women to be reasonable. And I expect you probably get some of that as well. And it kind of in what you're describing with the immigration system, that there's this expectation that emphasizing that relationship between the parents and making sure that both parents have a relationship with the children really gets prioritized over safety. And if you behave in ways that are not seen as being reasonable, as getting along, as facilitating relationships, it can really backfire for women. And women know this. The women we spoke to again across BC were very, very aware that they're in a catch-22, that if they disclose violence, if they disclose, if they engage the criminal process, if they engage the child protection process, that they could be accused of basically doing that to ruin the relationship. They can be accused of alienation. And so that has a really chilling effect on their ability to report violence in the first place.
Great, thank you. That's really interesting. And so picking up from this question, and maybe this time I'll go to Kim first and then Shalini, just to change things up a bit there. But so based on these kind of challenges and these interactions, what tips or suggestions would you have for shelter workers who are supporting women in this kind of situation? What should they be aware of? What could they do to help?
Yeah. So what the message I would want to give to transition workers is that there's really an opportunity to do something which I think the lawyers in the court system don't do very well, which is really to provide that overarching understanding that the system is not structured around women's needs. It's not structured around providing safety, and it's okay to say that, and it's okay to be really transparent about that. We know that anti-violence workers and transition house workers and community support workers, whatever those sort of different umbrellas are that they come under, they have a really, really protective impact on people, and people who are able to access that support actually have much better outcomes for on a lot of measures. They have relationships that kind of predate court and outlast court, so they bring a lot of continuity to the process that lawyers, and again, particularly if it's a legal aid certificate or something, that they aren't able to bring. They're also experts in violence, and as I mentioned, this expertise is really sorely lacking within the legal system and among a lot of the lawyers and other people that they may interact with. So providing that expertise that the legal system acts, the help with the safety planning, those supports, is just such a huge thing. There's also a lot of safety planning that really should be going on in courthouses, which we know are a site of abuse for a lot of women. So even things like planning, walking from the car into the courthouse. Is someone going to be with them in the courthouse so that they aren't alone in the hallway? Thinking about where the person is going to be if documents are being served on the other party, and that might trigger a response. So thinking through that kind of safety and risk lens. I know that most transition workers are very, very mindful of keeping records that could end up being subpoenaed or that could end up being cross-examined on. But I would also just say one thing that is very useful if there is trial, again, is because evidence is so hard to find that if there is evidence, encouraging women to document it, which is not always what people want to be doing when they're in the midst of fleeing a violent situation. But making sure that if there are really abusive or threatening text messages or emails, that those get captured somewhere, or messages that might get put up on Facebook and deleted later, that making sure that that gets captured so that there's a record of those, threats. If there are, visible physical injuries, maybe trying to help the woman get, maybe not a shelter worker, but maybe someone she knows that can help document them or take photos so that those photos exist later. Because even though it's very challenging, that information can actually be hugely compelling and really important in courts. And it's transitory and it vanishes. So if you can encourage maybe someone in her life, maybe a friend who's not involved in other ways and can't be dragged into being a witness in other ways, but who can help to document that information, that can be, I have been in court where that has been, I think, hugely persuasive to judges to actually take things seriously. Yeah, I'll leave it there.
Awesome, thank you. So I'll pass it over to Shalini to add.
Sure. So I just echo what Kim says around documentation. What's interesting on the immigration side is we routinely seek letters from shelter workers, support workers, transitional housing workers to support the immigration case. And what is so interesting about it is where the credibility of clients is often questioned by immigration officers, the credibility of those letters from the workers is not. It's given more weight. Right? So frontline workers in particular can play an incredibly important role in giving us evidence in support of the case to be made on the immigration side. My first just tip for frontline workers is a really easy one, which is something that people weren't doing before, but maybe are now, but ask what the immigration status of your client is. If they say citizen, you don't need to think about anything I said today. If they say permanent resident or something less, that in and of itself needs to trigger the organization and your work to think about the immigration piece. Not necessarily that you're going to take it on if you don't have the expertise, but that it's a live issue. Right? So that you don't want to miss it, because I think a lot of the people who come to my clinic just have way too much going on. And invariably, they want to talk about family law and they're not even thinking about the immigration side of their case. And in some cases, they let their status lapse, and that creates a whole issue of trying to get it back. All things that were preventative if we will figure out right off the bat if there's an immigration issue. And then don't leave it off. Right? If you don't know what to do, I still recognize that it's super hard to figure out what to do, but try to figure out in the area that you are in, who are some of the people you can lean on in the area that do practice in immigration? What are the legal aid services, and what advocacy do we need to do as people who work with people facing violence around access to justice? Because we're failing, right? We're failing all of these women on that side completely. Third tip, if you're totally flummoxed and confused, search up South Asian Legal Clinic of Ontario and just give me a call. I promise you I will do my best to get back to you and get you started on what you need to do. The fourth tip, don't take, oh, well, so-and-so did that, so that's going to work for me as advice. And I see that with my clients all the time, where they have these grapevine conversations, and so they think that that's going to work for them. It's just not always the case. Be on the lookout for consultants. There are many in the country who will take advantage of people who are particularly traumatized and take money for things that will not happen. I think on the immigration side, we give very real advice. It's just like what Kim was saying about what workers can do. We have to give very real advice to people and then let them have the agency to make the decision that they want to make, which may not be the one you want for them. But there's a question in the chat from, I think, Lisa around what do you do if the system is stacked against you? And in many ways, the immigration system is stacked against victims of violence in these situations. What we do is we give them all of the information we can. We take a look at who can advocate for them. We give them our best opinion on chance of success. And then we let them make the decision that's right for them, which I I've been doing this for a long time, and I still find it hard when women choose something different from what I'm hoping they'll choose, but I understand it. I think we all do, right? There are so many more complexities than just that one piece. In working with South Asian communities, the family pressure sometimes adds another layer of complexity. So it's about sort of making sure they're just equipped with the knowledge, the understanding, and what in their jurisdiction is possible for them. What are the supports? And if you can be behind them, that you will be. When I think about it, I think we need to do much more in terms of training for frontline workers on the immigration side, because the reality is more and more people are coming to your doorsteps to get immigration help because there just isn't that help anywhere else. So we have to deal with that reality across the board and think about how do we train up people so that they feel a little comfortable to do this kind of work, because it's not easy.
All right, excellent. So there are some questions coming in, as you mentioned, which is great. And I'm going to go to those in a minute. So this is a great time to put your question in the Q&A if you haven't already. But before I do that, I have one last question for the two of you. And I'll ask you maybe to keep your answers to a minute or so each, just so we get to the audience questions, although I know this is a big question, so sorry. But just wanted to wrap up, a few weeks ago, we had a different webinar with some other speakers about legal bullying. And some of those presenters, they were talking about, how abusers can kind of use the family law process to continue the abuse. And so I was just wondering if each of you could speak quickly to, and I'll go to Shalini, you first, to how can abusers use, and you mentioned this at the beginning a bit, but some other things, use the immigration system to kind of continue perpetuating the abuse. And then Kim, I'll come to you for criminal.
Yeah, on my side, it's really simple. You hear it all the time. I'm going to get you deported. I'm going to get you removed. I'm going to make sure you don't get permanent residence. So it's really using the immigration system to create immigration precarity for the person. And I wish I could tell you that none of those things are true. I can't get anybody deported. That's up to immigration authorities to decide, but I can make a complaint and I can pull an application to sponsor my partner at any time if I want to, right? And I can remove that person from my own application for permanent residence if I want to. So those threats are really very live and very real, and they really do create a whole another level of violence. That in and of themselves are a form of violence, right?
Thank you. Kim?
Yeah, so it's generally it's a little bit harder for them to use the criminal system than the family system, because they have less control over it. The two main things that I would say that we see are some abusers, and particularly abusers we were finding in the North when I used to work in the North, who had been through some of the domestic violence treatment option courts. They would learn the language, they would learn how the system worked, and so then kind of using that knowledge and learning, and then trying to have women charged when they were acting in self-defense, or even if they weren't, the woman would call for help, and then they would basically try and get them charged instead. So that's one thing that we've really seen, I think, sort of across the board, an increase in. And then the other piece that I think is somewhat common, again, is using the courthouse as that opportunity to continue harassment or to intimidate. So potentially trying to take pictures of the person outside the courtroom. In Canada, you aren't allowed to take pictures inside the courthouse, but coming in or going out of the courthouse or outside the courthouse, and sometimes bringing in friends or family members or groups of people to sit in the open court and sit in the in the audience and kind of be an intimidating factor during trials. That's something that we've seen as well.
Okay, awesome. Thank you. Well, this has been a really interesting discussion so far, and I think it'll continue with these questions here. So I'm going to start with the ones we have already, and feel free, those of you listening, to keep adding. So the first one kind of picks up on, both of you were talking a bit about evidence at the beginning. So someone asking, if a client records the abuser with their phone or audio, does that help her case? Will the police take that into consideration? So I'm not sure either of you can answer that.
So I wish there was an easy answer to that. There isn't. It really, I think, depends on what's being shown in the phone or audio. bear in mind that in a criminal proceeding, any information which is given to Crown or the police will get disclosed to the defense before the trial. So there is an asymmetrical obligation for evidence in a criminal trial. The Crown and the police have to, and any information which is provided by the victim has to be turned over to the accused person. It doesn't work in both directions. So the accused person has a right to remain silent throughout their trial and not share any of the information that they have, except for what they might decide to pop up with at trial. So if she turns it over to police, police will then be giving it on to Crown and it will get passed on. In a family proceeding, it really can go either way, sort of depending what it is. There isn't a rule, at least right now, there isn't a consistent rule or approach to the way that that type of information is dealt with. It's not sort of automatically kept out, whether or not the person consented to having the recording made. It can get entered in court. There is the potential for it to backfire. So sometimes judges will say, like, taking videos or recordings without the other person's agreement, that it will be seen as petty, it will be seen as not contributing to that positive relationship, to getting along, to sort of working together to parent the children. So in some cases it can backfire. In other cases, having that clear evidence can be really important, and courts will take it in and will say, okay, this is this is something which affects the best interests of the child. One thing I would really just caution, if we're on that, I would just be very cautious about having clients videotape children speaking. And there's a real risk, particularly in family court here, that gets seen as coaching. That the court thinks, okay, mom set up the kid to say this terrible thing about dad and then filmed it, and it's all been set up and sort of is coerced and coached. So there's a real risk around that. And if there is information from a child, I'd really, whatever you can do to get in touch with, if you're in BC, you're welcome to contact us. But really trying to make sure that she gets some advice around that before doing it.
Did you want to add anything?
Just on the immigration side, the evidentiary rules are very interestingly looser. Basically, it's up to immigration officers to weight and give credibility to whatever evidence you put in. We frequently put in copies of text messages or messaging on social media platforms that are, that provide evidence, and we put in transcripts of phone calls as well. And depending on the immigration officers looking at that case, they will be taken very seriously. They may not be taken seriously. On our side, what's really good is whatever is put in is not provided to the other side. So it's your immigration application with your evidence. That person has no standing to provide any information in your application. And so that is relatively, it's not confidential, it's going to a stranger at a very large bureaucracy of IRCC, but it's safe from having become known to the person on the other side, the accused.
Awesome. And so we have a question in the chat here about, both of you kind of spoke to maybe actors in the legal system not understanding family violence and what that can mean. So someone asking here, do you think that having a consistent screening process completed by parents or parties going through the family court process would provide judges with more information about domestic violence present in each family's experience, and could then assist their decisions around parenting time and those other pieces? I'll go maybe Shalini, and then we can go to you, Kim.
I mean, it might. So I've been doing actually in Ontario a significant amount of training around family violence and what it looks like in racialized communities for family court judges specifically. And it's been very challenging trying to have people, they sort of say they know, but they don't know. Right? That's the reality of what's happening. But the fact that they're finally actually having meaningful training and dialogue and exchange on it is a really important thing. They, from my perspective in Ontario, I am told repeatedly they're trained extensively on violence, right? This is what we're told. But that's not what you see. I mean, during COVID, I was in a motion where we couldn't get supervised access going because all the centers were closed, right? So they wanted to order somebody else to supervise it, and they were saying that they were going to order her sister-in-law, which is the sister of the person who had been seriously violent to her. And how can that be a neutral order? And that sister-in-law lives in that household, is also a victim of violence herself, right? And so there was a complete not understanding of really what the reality was there. So, I think a screening tool might be a good advocacy piece. I think we definitely need more training. And I also have spoken significantly about some consequences, right, for the judiciary and the bench. Some of the decisions that we've seen even come out on the immigration side, the Immigration Refugee Board, and the comments made by decision makers around assumptions around violence are disgusting. Yet the bench and decision makers seem to have a level of impunity that we need to really start talking about as well.
Yeah, it's so interesting to hear you say that, because I would say we have very similar conversations here. In fact, I went to a meeting with a fairly high level lawyer committee a few weeks ago, where we were basically told that lawyers don't need training and that lawyers already know how to do this. And we know from talking to hundreds of women across BC that people aren't asking these questions. They're not doing the screening. So, and I've had similar conversations with judges as well, that judges already know how to do this. And I sit in court and I go, I'd like to order parts of this transcript, and maybe it's not part of the reasons, or maybe it's not part of something that gets published, but just comments that are made in the duration of the court case that are incredibly problematic and make a lot of assumptions. So it's really an uphill battle. And it is funny to me that I think there's not very much of an acknowledgement within the legal system right now that it is an uphill battle. I think, generally speaking, screening structure that's going to force people to grapple with it is sort of generally good. I think I share Shalini's kind of, I think it would be helpful. It probably won't be a magic bullet because we have such a long distance to travel.
Okay, awesome. So we have a couple minutes left. So what I'm going to do with these last two questions is put one to each of you, because they are sort of about the two different areas of law. So I'll start with Kim. And there's a question here about how much does the Victim Bill of Rights play into a criminal or family case? Is it being outwardly practiced? And if not, at what point should we advocate on behalf of our client and her victim rights?
So I would say not at all in family law. I have not seen a lot of reference to it in criminal law, is the truth of it. I mean, I'm familiar with it, but I have not seen it used in a meaningful way. And I have not seen people within the criminal justice system sort of being held accountable to it or really using it to make decisions. So I would say, any point you want to start advocating for it is probably a good point to start. Again, the reception may be very mixed depending on who you're dealing with, but using that as a tool to point to, and trying to hold the system accountable, I think anytime you want to start.
Great. Okay. And so for our last question here, Shalini, so someone asking, is there a way to protect women who don't have status, who might want to leave their violent partner? Can they still be deported even if they have children in Canada? And would they then lose custody of those children?
Okay, so it's actually a positive question to answer on instead of raging against the machine, as I have been doing. There are two pilot projects that were introduced a couple of years ago. They're still pilot projects. They're not in the law, but they're still in place. One is called a temporary resident permit for family violence, which allows you to apply for someone without status to get temporary status that actually makes them eligible for healthcare, a work permit, social assistance when they're dealing with a family violence situation. There's also something called the fast track humanitarian and compassionate application, which will allow immigration to give permanent residence to people facing violence, and they will look at those applications a little bit quicker and look at violence as one of the significant factors. In every immigration application, the Supreme Court has said the paramount consideration is the best interest of a child. So when children are involved and they're in Canada, that argument should be made significantly in the TRP, in an H&C, in an extension of a visitor visa. officers must consider, just like the changes in family law, right? Must consider the best interests of the child. And in those cases, there is actually good success in making sure that women aren't removed and they stay and that they're with their children. It's been pretty rare that women are removed when a family court order says that they have decision-making and parenting time with their children who remain in Canada. But you just need to make those arguments. Fast track, I'm going to really quickly respond to fast track. I don't know what that means. Humanitarian and compassionate applications take 3 to 4 years to process. If you note that it's a family violence application, you may be able to get a decision within three months to 12 months. So that's what fast track means. They may process it faster than waiting 3 to 4 years.
Awesome, thank you. And maybe what I can do when I send the recording around to folks is include maybe some of these, because you've mentioned a few resources, the steps to justice, and then the names of some of these programs. So I can include those in the email that I send out to folks in case you didn't catch it just as it's being said here. So with that, I just want to say thank you both so much for this. It's been a really interesting conversation, lots of really interesting ideas, both around challenges and systemic issues, but also some of the kind of positive and interesting ways that these different systems can kind of interact and even support some of these cases. And I can also include contact information for the South Asian Legal Clinic and Shalini, because a few people have mentioned that.
I think I put my email and phone number in the answers to the chat question.
Yes, so I will include that when I'm sending out the email there as well, so everyone can see that. Yeah, so thank you both, Shalini and Kim. Thank you to the interpreter, and thanks to everyone who's participated today for this conversation. When you close the webinar, you will be taken to a feedback form. If you want to take a minute, give us some thoughts on today's webinar. We do always look for ways to improve, so please do let us know. And with that, I'll say thank you and goodbye. Have a great day to everyone. Thank you.